Today's webinar, as I say, is on Irish constitutional change. We are coming towards the end of this decade of centenaries, and I think it was Dr. Bláthna Ruane and Dr. Thomas Mohr who originally had this idea of building something around these dates, and we thought this would be something that could work very well in this online format. So I'll introduce our three speakers individually. We've given them a strict deadline of 15 minutes maximum, and threatening to cut them off then, because we do want to leave plenty of time for questions and discussion at the end. So our first speaker is John Larkin QC. He is a practicing barrister at the Bar of Northern Ireland, of course a former Attorney General for that jurisdiction as well, has done some brilliant work for the Society and some brilliant scholarship on Irish legal history in the past. And tonight he's going to talk on One Irish Constitution, Two Irish Parliaments, the Government of Ireland Act. And so over to you, John.
Thank you very much, President. Two political traditions have largely succeeded in conveying a distorted image of the Government of Ireland Act 1920. The Republican separatist tradition, having chosen to neglect at the time almost all of the opportunities that the Act afforded, was content to denigrate it as partitionist. The unionist mainstream, in later years at least, was content to celebrate the Act in partitionist terms as the Constitution of Northern Ireland. Both the denigration and the celebration of the 1920 Act as partitionist are misreadings. The 1920 Act was enacted against a background of an intensely and bitterly divided Ireland, and while it contained provisions that acknowledged intense and bitter divisions, it also made provisions for the reduction and removal of those divisions. Separatist Republicans, preferring greater separation from Great Britain over Irish unity, chose not to work the provisions designed to remove Irish division. Unionists were content to operate those provisions that acknowledged existing Irish divisions and found no partners in the provisions that sought to remove those divisions. It came later to suit both Republican separatists and Unionists to characterise the Government of Ireland Act 1920 as the Constitution of Northern Ireland. But even the short title of the statute confirms that it had much larger ambitions. Viewed properly, the Government of Ireland Act is the first Irish constitution of the 20th century to come into force, as the 1914 Act did not. And of course, it remained in force, albeit in attenuated terms, until repealed with effect from December the 2nd, 1999, as affected by Section 2 of the Northern Ireland Act 1998. I first encountered the Government of Ireland Act 1920 as a law student in the 1980s, and one or two of my contemporaries and all of the public law teaching staff at Queen's appeared to have a maroon pamphlet published in 1969, another resonant year in Irish history, called the Constitution of Northern Ireland. So a visual aid, I've since acquired one, and I see Mr. Justice McAlinden. I suspect he was one of those very diligent students who had a copy of that pamphlet at the time. But even in the Constitution of Northern Ireland, as published in 1969, the ghosts of an all-Ireland solution still haunt its pages. From its long title, through the frequent appearance, italicized words, the Parliament of Southern Ireland, right through to the reference to the Supreme Court of Southern Ireland in Schedule 7. As is well known, the Parliament of Southern Ireland met only twice, on June 28, 1921 and July 13, 1921. According to Sir John Ross, the last Lord Chancellor of Ireland, it was well known that only 4 members of the House of Commons, the university members, would be present. That being so, Sir John said this: as it was plainly only a formality, I arranged that there should be no uniform, no guards, or show of any kind. Readers of Sir John's memoirs will know he rather liked ceremony, so the decision to forgo a show of any kind must have been a hard one. It is also well known that the Parliament of Ireland met with quite a show in 1921 and continued in existence as a legislature until, to use the typically economic formula of Bridget Hadfield, in 1972, it all came to an end. In this short talk, I want to talk about two All-Ireland features of the Government of Ireland Act that vanished in the settlement introduced by the Articles of Agreement for a Treaty of December 1921. And these are first, an altered office of Lord Chancellor of Ireland, and second, a new High Court of Appeal for Ireland in which the Lord Chancellor presided. Section 38 of the 1920 Act did three things. First, it abolished the existing Supreme Court, High Court and Court of Appeal. Second, it replaced that court by Supreme Courts of Judicature in both Irish jurisdictions for the establishment of a High Court of Appeal in Ireland, exercising appellate jurisdiction throughout the whole of the island. There were little judicial overlap between these two Supreme Courts, but while the Judicial Commissioner of the Land Commission was an additional judge of the High Court of Justice in Southern Ireland and an additional judge of the High Court of Justice in Northern Ireland, he was only so for the purposes of his powers and duties in relation to land purchase. In contrast, the Lord Chancellor of Ireland was a member of neither of the two Supreme Courts. Instead, he presided over the High Court of Appeal for Ireland. More significantly, the Lord Chancellor lost all of his executive functions, including that of Keeper of the Irish Great Seal, and retained only judicial functions, acquiring at the same time the same tenure as the other judges, as the judges of the two Supreme Courts. This was not less than a revolution in the nature of the office. The Lord Chancellor of Ireland had been at the heart of the Irish government, and while certain 19th century chancellors were remarkable for legal learning, others were notable mainly as members of the Irish executive. The new Lord Chancellor was now insulated from politics, the better to enhance his judicial status. During the second reading of the Government of Ireland Bill on March 29, 1920, the Irish Chief Secretary, Ian Macpherson KC, soon to be replaced by Hammer Greenwood, said, "It is also proposed to establish a High Court of Appeal for the whole of Ireland, to which appeals will lie from any decision of the Court of Appeal of Southern or of Northern Ireland. The High Court of Appeal will thus exercise jurisdiction throughout Ireland and will form an important link between the new two Supreme Courts, securing the interpretation of the law and the application of legal principles." The High Court of Appeal had three ex officio members: the Lord Chancellor himself, who presided, the Lord Chief Justice of Southern Ireland, and the Lord Chief Justice of Northern Ireland. The court was normally required to sit as a panel of three judges, Chancellor and the two Chief Justices, or each Chief Justice could be replaced by a judge of his nomination. There did not appear to be any provision for the Lord Chancellor to nominate a judge to sit in his stead in the three-judge formation. If the Lord Chancellor considered that the importance of any case made it advisable, the court could sit in a panel of five judges, in which case the court consisted of the Lord Chancellor and two judges each from the two Supreme Courts, normally of each jurisdiction, or judges nominated by him. If the Lord Chancellor was unable to sit, then the court consisted only of four judges of the two Supreme Courts. Two linked features are notable. Firstly, the maintenance of a formal balance between the two Supreme Courts and the inability of the Lord Chancellor to nominate a replacement for himself from either of those courts. The only court of which the Lord Chancellor was a member was the court of which he was president, and it was evidently considered right to put a barrier between him and the individual judges of the two Supreme Courts as respects the composition of panels for the High Court of Appeal, even if that came at the obvious risk of an evenly divided court when the Lord Chancellor happened to be unavailable. A similar presentational concern appears in the absence of any fixed seat for the High Court of Appeal. It sat in the jurisdiction of the court appealed from, and in the absence of the Lord Chancellor, the Lord Chief Justice of the jurisdiction in which it sat presided, but otherwise precedence was determined by the priority of date of appointment. No judge could sit on the High Court of Appeal to any case in which he had sat either at first or at second instance. This seems now such an obvious arrangement, but it will be recalled that the annals of 19th century litigation afford many examples of judges who sat both at first and second instance. Even today, in the European Court of Human Rights, the judge in respect of a respondent state can sit in chamber formation and can continue to sit if the case goes to the Grand Chamber. There were three strands of the High Court of Appeal's jurisdiction. First, an appeal lay to it from a decision of the Court of Appeal in either jurisdiction. Second, it took over the limited criminal appellate function of the Court for Crown Cases Reserved. Third, in any case in which the decision of any court involved the question of the validity of any law made by or having the effect of act of either Irish Parliament, and that decision was not otherwise subject to appeal to the Irish Court of Appeal, the existing Court of Appeal, then an appeal lay to the new High Court of Appeal. Quite early in its existence, the High Court of Appeal had to deal with a challenge to its jurisdiction. On June 28, 1921, the County Court judge for County Armagh made a decree for £19 by way of compensation for a gun and other chattels taken away and the destruction of 2 hats. The County Council appealed to the Judge of Assize, Mr. Justice Mohr, who affirmed the decree, whereupon the County Council, nothing daunted, appealed to the Court of Appeal for Southern Ireland, which dismissed the appeal on November 9th, 1921. The County Council then appealed from there to the High Court of Appeal in Ireland. Parenthetically, in his memoirs, Sir John Ross refers to his own experience as a landowner where his country house, Dunmoyle, was raided on 2 occasions, and on the second, the miscreants carried off a large quantity of things to the value of about £200, principally mattresses, quilts and blankets. But Sir John Ross took the view that while existing Court of Appeal authorities allowed for items taken away, he disagreed with that and did not put in a claim for items merely taken away. Now, the challenge in the County Armagh case turned on the interplay between Section 8 of the County Court Appeals Act and Section 43(1) of the Government of Ireland Act. Section 8 of the County Court Appeals Act empowered the Judge of Assize on the hearing of a County Court Appeal to give special leave to appeal to the Court of Appeal on a question of law, and provided that the decision of the Court of Appeal on that question of law was final. Section 23(1) provided for a general right of appeal from the Court of Appeal in either Irish jurisdiction to the High Court of Appeal. So, which of the 2 provisions were to prevail? The specific provision making the decision of the High Court of Appeal, or the Court of Appeal rather, to be final, or the general right of appeal conferred by Section 43. The case was argued on December 21st, 1921, and judgment was delivered on January the 16th, 1922. I pause there to observe that for a case to pass from first instance judgment in June 1921 through second and third instance hearings to fourth instance judgment in January 1922 is a shining example of judicial expedition and almost unthinkable in the changed circumstances of our own time. Sir John Ross was clearly aware of the constitutional responsibilities of his new court, and he set out the interplay of the institutions created by the 1920 Act in a passage that bears quotation in full, but given the passage of time, I won't give it. Suffice it to say that he discerned in the 1920 Act arrangements a federal system internal to Ireland, and saw the High Court of Appeal as absolutely central to that system. And the High Court of Appeal, having determined that it had jurisdiction to hear the appeal, then faced an argument at the substantive hearing on January 18 and 19, 1922, that it was bound by earlier decisions of the Court of Appeal in Ireland. These decisions being those that Sir John Ross, in his personal capacity as a claimant, had disagreed with. Fairly effortlessly, the Court of Appeal brushed this aside. The substantive hearing gave Sir John another opportunity when delivering judgment on February the 10th, 1922, to set out his vision for the court. This High Court of Appeal, he said, has a more extensive jurisdiction than any appellate tribunal that has hitherto existed in Ireland. It is not a substitution for any former appellate court. It is the High Central Court, which is necessary for the determination of the mutual rights and obligations of the component parts of the federal system contemplated by the Act of 1920. It is the supreme guardian of the Constitution and the pivot upon which all the constitutional machinery was intended to turn. The expression guardian of the Constitution has, of course, been applied interrogatively to the Judicial Committee of the Privy Council in respect of the treaty by our colleague Thomas Mohr in his splendid book on the Privy Council. But by the time Ross pronounced those words, they could be no longer regarded as descriptive. Article 75 of the Irish Free State Constitution provided that pending the establishment of courts by the Oireachtas pursuant to Article 64 of that constitution, the Supreme Court of Judicature, county courts, courts of quarter sessions, and courts of summary jurisdiction as at present existing were kept in place. There was no place for the High Court of Appeal, which was brought to an end by paragraph 6 of the schedule to the Irish Free State Consequential Provisions Act 1922. The very last case decided by the court arose from a land dispute in Cork, and on that case the two Chief Justices were present, and again the Lord Chancellor presided. By way of coda to the case, it is pleasing to note that Mr. Leyburn, the original claimant, County Armagh, did not go away entirely empty-handed, and while the High Court of Appeal overturned previous Court of Appeal authority that compensation under the Malicious Injury Code could not be awarded in respect of items taken away, the consolation prize that he continued to receive compensation for the two hats that were damaged in the raid. And I can't help thinking of our dear colleague and friend Niall Osborough when recalling that picturesque detail of compensation being awarded for the two damaged hats. So, the question that, stepping back a little and looking at the Act as a whole, that I'm prompted to ask is, what is the difference between unity and union? Unity is the concept confidently invoked in the preamble to the Constitution of the Irish Free State in 1922. Union of Northern Ireland and Southern Ireland is the purpose of the Government of Ireland Act 1920. And it seems to be that unity is a stable or static condition that can be restored, reunification, but union is a process. The 1922 Act speaks of unity as a thing to be restored by that Act. The 1920 Act speaks of union as a thing to be achieved through the working of that Act. From our vantage point, I wonder whether the premise of the 1920 Act has proved to be the sounder of the two. No one writing about the period 1920 to 1922 can properly ignore the diaries of Mark Sturgis. In his last entry for 1920, he notes the assessment of the Act, the 1920 Act, given by Stephen Gwynn, the former Irish Parliamentary Party MP for Galway City between 1906 and 1918. According to Sturgis's note, Stephen Gwynn, he says, saw the Prime Minister lately and said that we were neglecting to advertise the Home Rule Act, that it was not at all bad, and that we had not so far troubled to boom its virtues in Ireland at all. It is plainly too late to advertise the Home Rule Act, but it is not too late, I think. In fact, it is high time to recognise that the 1920 Act was not at all bad, and to use the colloquialism of an earlier age, ought we now to boom its virtues in Ireland. Thank you very much.
Thank you so much. And it's something I probably should have mentioned at the start. It might be helpful if maybe not everyone, but if a good few people switched off their camera, just it can, I think, interfere with the connection. So just in terms of making sure that we have a good connection, especially when we're recording it. But I think that worked well. But a couple of times it just seemed like it was about to go. Okay, our second speaker is Dr. Bláthna Ruane SC. She's a practicing barrister at the Bar of Ireland. She's written widely on the Constitution, law and government, and was a member of the Constitutional Review Group in the 1990s. And today she's going to talk about the so-called treaty, the implications of legal form for achieving settlement.
Thank you, President. I hope you can hear me satisfactorily, can you? Fine, well, then I'll motor ahead. Thanks, obviously, to the Society for inviting me here today. This legal history audience is already, I think, very familiar in general terms with what the Anglo-Irish Treaty involved. Its provision for Irish Free State Dominion status, Canada style, but with extra restrictions, the oath of allegiance, the right of Ulster to opt out, an Irish contribution to the public debt, defence arrangements, retention of British access to Irish ports, maintenance of an Irish army, religious freedom and transitional arrangements. Now, instead of looking at all of these individual provisions, I have thought that really it might be more interesting for a legal history audience to concentrate on the elements of the consequences of achieving a settlement through the legal mechanism of a treaty. Now, the previous attempts at settlement of the Irish problem, as Westminster looked at it as being, were done through internal constitutional arrangements by Westminster legislation, providing a statutory grant of limited powers. A treaty, on the other hand, was well understood by that time as an agreement between two countries which are separate and distinct states. By July 1921, there was pressure on Prime Minister Lloyd George, leader of a Liberal Conservative coalition government, to grant Dominion status to Ireland, which he had hitherto resisted. Dominions were self-governing but not fully sovereign and subject to certain imperial restraints. Dominion self-government was rooted not on treaties, but on a British statutory grant of rights. Dominion powers had, however, evolved, and by 1919, it was thought that the Dominions could probably secede from the Empire. When he met Lloyd George in London in July 1921 for exploratory talks, De Valera demanded a treaty as the legal mechanism for a settlement that would recognise and accept Ireland's independent status. A treaty was also sought because Sinn Féin feared that any settlement made through British legislation might later be reversed by them. Towards the end of the July negotiations, Lloyd George decided to make his best settlement offer even before formal negotiations began. He offered restricted Dominion status, but significantly, he offered settlement through the mechanism of a treaty. The offer of a treaty, with its recognition implicitly of Ireland as a separate state, ran directly counter to long-standing British theory of Ireland's legal status as being an inherent part of the United Kingdom since, at the very least, the Act of Union. Lloyd George's proposal to offer a treaty was startling, indeed maverick, and when it came before the British Cabinet, prior to his making the offer, it met with considerable opposition, described unsurprisingly as having caused a lot of heartburning. There was Cabinet concern about the use of the term treaty because it would be a dangerous precedent for India, and also, critically, because it involved a recognition of the Irish Republic, which would be a problem in the event that the negotiations broke down. It was only accepted because of Lloyd George's statement that the Irish had insisted on it, and because of his references to other treaties with Scotland, South Africa, and the Treaty of Limerick. Now, in reality, those were not comparable analogies within British legal theory because of Ireland's status since the Act of Union as an inherent part of the United Kingdom. Despite having offered to deal by treaty, Lloyd George still attempted to adhere to the British rejection of Ireland's claim to independent status. He spent August and September of 1921 corresponding with De Valera on whether negotiations could take place, in the course of which he explicitly denied Ireland's independent status. That denial continued throughout the formal negotiations and indeed the ratification process, during which the British government denied that it had recognised Ireland was an independent state, but continued to insist that the settlement was a treaty. There was thus a serious inconsistency in Lloyd George's negotiating strategy regarding Ireland's status. On the one hand, his offer had already recognised existing Irish independence. On the other hand, if he still denied that independence, then he was engaged in changing the internal constitutional arrangements, but in an unconstitutional manner, without parliamentary consideration and negotiation of its revision. Lloyd George, however, would not be restricted by these theoretical legal constraints, and he proceeded firmly and opportunistically on the basis that he was negotiating a treaty. The tactical advantages to Lloyd George of offering a treaty were huge, because by categorising what he was offering as a treaty, negotiations could be conducted by the British government alone, directly with Irish representatives, to the point of a concluded agreement, rather than through a parliamentary process of consideration and bargaining over draft legislation. Only when a concluded agreement was reached would the British government be obliged to go to Parliament to get approval and ratification. That rendered the negotiation process far more secret and confidential and allowed for greater manoeuvrability. It would then give Parliament only a take it or leave it choice over whether to accept the terms. Redrafting would not be an option without Irish consent, which was readily understood as likely involving the collapse of the settlement and indeed of Lloyd George's government. Despite the risks, he chose an unprecedented strategy which gave him the negotiating benefits of the treaty mechanism and would give the Irish negotiators what De Valera had demanded, while simultaneously using every opportunity to deny Ireland's existing or future independence. Now, for the Republicans, settlement by means of a treaty implicitly recognising Ireland's independent statehood and which could not be altered unilaterally by later British legislation was a major breakthrough. The sting was that they could only get that by accepting a simultaneous downgrading of that independence to restricted dominion status. Another problem was that even if other dominions could later secede from the Commonwealth, Ireland might potentially be prevented from doing so by virtue of their separate treaty obligations, to which none of the other dominions were subject. An overall agreement very similar to what Lloyd George had originally offered was reached on the 6th of December. The title was Agreements for a Treaty between Great Britain and Ireland. It was signed by what were described as the members of the British and Irish delegations. The treaty had then to go through an approval and ratification process on either side. Legal issues regarding the treaty mechanism arose immediately on both sides in the effort to have the agreement approved. In Britain, very senior legal figures, both within the Commons and within the House of Lords, challenged the constitutional validity of making a so-called treaty with what was, in British legal theory, a part of the United Kingdom. The objection was that the United Kingdom could not make a treaty with a part of itself or with individual subjects of the Crown. It was furthermore argued that Lloyd George's procedure was unconstitutional because any regional rearrangement would only be an internal constitutional agreement and had to be subject to more stringent parliamentary involvement and scrutiny than he was embarked upon using. In Ireland, debates over the treaty were particularly bitter. De Valera challenged the validity of the agreement, saying that the plenipotentiaries were not entitled to sign without reverting back to what was the cabinet of the second Dáil, and that the Dáil members could not approve or ratify the agreement because it was ultra vires the Dáil, which was bound to uphold the Republic. The treatyites said that the plenipotentiaries were responsible to the Dáil and not the cabinet, and they also asserted that the agreement was an international treaty under which Ireland, as a separate state, accepted dominion status and was at a stage on the road to achieving a republic. The anti-treatyites also attacked it because the constitution would be regulated by the British and would derive from a British act. The treatyites argued that the constitution would derive from the Irish people and not from any act of the British Parliament. However, because of the majority political support for the settlement on both sides, after a horrendous war of independence, those serious legal issues remained just that, unresolved issues, but they didn't actually prevent approval on both sides in Britain by large majorities and in Ireland by a small majority. The parliamentary process does not deliver a considered judgment, it delivers a vote. The first step in Britain's legislative ratification was in March through the Irish Free State Agreement Act. Throughout those debates, Lloyd George's tactics of continuing to categorise the agreement as a treaty, changing internal constitutional arrangements without prior parliamentary scrutiny, and preventing debate were seriously attacked all over again. Nevertheless, the bill passed. Every time an issue came up for either a clarification or an amendment, they would be met by Churchill saying to them, you can either vote in favour or you can vote against, but you cannot alter, you cannot change. If you do that, the agreement has to be renegotiated and then it will collapse. And probably the government will collapse as well. The Act as passed gave the agreement the immediate force of law. It provided for the transfer of powers to a provisional government provided for under the treaty. It also provided that the Parliament of Southern Ireland would be dissolved within 4 months and elections were to be held as quickly as possible to create a new Parliament, which was intended to adopt a constitution. The Act also provided for the Ulster month, during which Ulster could opt out from the arrangement, would not start to run until a later British Act was passed, adopting the constitution. That was to enable Ulster to see the Free State Constitution before making its decision. And that was actually very important to the treatyites. Meanwhile, the treatyites had prepared a draft constitution which they hoped would limit British control. But the British rejected it as a republican constitution and threatened military action. It was quickly redrafted to render it consistent with Dominion status. The revised constitution was made public immediately before the election of the 16th of June. That election gave the treatyites a majority, but it was not actually a plebiscite on the treaty or on the constitution, although obviously it had major significance under both heads. In October, the Constitution of the Irish Free State Act was passed by the new Irish Parliament, or Third Dáil, sitting as a constituent assembly, to enact a constitution and to implement the Treaty of 6th December. That act was framed so as to maximise the basis for claiming an Indigenous Irish authority for its adoption. However, it also provided that the constitution was to be construed in accordance with the treaty, and it enscheduled both the constitution and the treaty. It also gave the treaty the force of law and was therefore regarded as being the Irish legislative ratification of the treaty. The final British legislation was not passed until early December. And even at a very late stage, just before that, there was concern as to whether the final British legislation would ever proceed at all. Lloyd George, who had spearheaded the agreement, fell from power in October and was replaced by a conservative unionist government. In the event, British public opinion was such that the Conservatives decided not to try to unpick the treaty that Parliament had approved twice already, and with civil war raging. The legislation was given the final imprimatur by the British Parliament in early December on the strict basis that it was a Dominion-type constitution within the four corners of the treaty. The Irish Free State Constitution Act was passed by Westminster on the 5th of December. The Act deemed it to be the act of ratification of the treaty for the purpose of the Ulster month. The last step was taken the next day when the Royal Proclamation issued. Now, standing back from it all, you can see that the settlement by treaty greatly facilitated getting approval in Westminster. Lloyd George's stage management of the approval and ratification process effectively went through the motions of parliamentary oversight, but in reality allowed no amendment of its terms and thus bypassed much British controversy. The treaty settlement came before Parliament as a done deal, tucked away in schedules to the Acts, rather than set out in the main text. The treaty could not be renegotiated line by line in parliamentary debates. This was a vastly different process to the parliamentary trench battles of earlier settlement attempts. It benefited from the great change in public mood in favour of peace and ensured that the agreement did not get snarled up in unionist amendments and opposition, despite the forceful criticisms of Lloyd George's legal strategy. The negotiating dynamic in 1921 was also very different because Sinn Féin would not participate in Westminster. That had, of course, arisen in the context of the 1920 Act as well. Like Lloyd George, the Irish benefited, however, from being able to negotiate directly and from being able to take it on a take it or leave it basis to the Dáil. Negotiations realistically between two parliaments would not have worked in the circumstances. So in reality, a settlement mechanism was going to have to involve direct person-to-person contact between the leaders on the two sides. And Lloyd George's adoption of the treaty mechanism for his own best interests actually facilitated that, and probably without it, the settlement would never have actually gone through. Settlement by treaty did not, after all, avoid British legislation, but it did at least fix the terms of the agreement and couldn't be changed unilaterally by the British Parliament subsequently. Apart from facilitating the reaching of a settlement, the treaty mechanism also boosted the treaty-eyed view of the Free States' indigenous root of title. It bolstered their assertion that Ireland was indeed already independent and that its independence had been recognised in the very instrument of settlement. That was a symbolically important achievement, despite the huge anger at the other elements of the treaty. The treaty mechanism was an important part of their legal narrative. Although they were compelled to have their constitution approved by the British, and it didn't come into force until the British had passed their December Act, the treatyites had ensured that the various legal steps required for the approval and ratification of the treaty and the adoption of the constitution were carried out in a manner that was consistent with their assertion of independent statehood. It required very careful legal choreography. Whilst Britain could claim that the creation of the Free State and the Irish Constitution were creatures of a British Act of Parliament, the treatyites could counterclaim that the settlement was by treaty and the Constitution was actually adopted by the Third Dáil, whose legal title went back to the Declaration of Independence by the First Dáil. Their argument was that it was an independent Ireland that accepted the treaty and that the compromise of restricted Dominion status was accepted on that basis only. That it was a real treaty was recognised by its manner of implementation both in Ireland and in Britain, by the process of approval and ratification. The Free State's root of title was thus not based on British legislation, but had its origins in the very treaty itself. I think one can look back on the process and say that Lloyd George's strategy was maverick. It was undoubtedly opportunistic because he had had no thoughts whatsoever of a treaty before he met De Valera. In fact, he had taken a long time to come back or to come around to the idea of Dominion status. So it was a huge change to opt for settlement by means of a treaty. It was full of legal inconsistencies and was unprincipled in many respects. But in reality, pragmatically, it proved to be an important element in reaching the settlement. And paradoxically, it vindicated De Valera's own demand for settlement by treaty back in July 1921 in his assertion of Irish independence. Thank you.
Absolutely wonderful. Thank you so much. And two superb papers. And our third paper, we're delighted to welcome another council member, indeed, our vice president, one of our two vice presidents of the Society, Dr. Thomas Mohr, associate professor in the Sutherland School of Law at UCD, the author of a book that's already been referenced today, Guardian of the Treaty, published by Four Courts Press in association with the Society. And he will be speaking on what did Irish people think of the Irish Free State Constitution in 1922?
Okay, thank you for that very kind introduction. Thank you for the two wonderful papers that preceded mine. Now, I actually have some visuals and I'm hoping that I can share the screen and bring those up. There we go. I hope you can all see those. Okay, so what did people in 1922 think of their new constitution? Very briefly, in just 15 minutes. Okay, well, on the day that our current constitution, that is the Constitution of 1937, came into force, De Valera declared it to be the first free constitution of the Irish people. Now, this was an obvious slight against the preceding 1922 constitution, which had just been abolished. That constitution had come into force just 15 years earlier. Maybe I'll just change this. On the 6th of December 1922, the 1922 constitution had come into force, a date right in the middle of a bitter and depressing civil war, meaning that any kind of official celebration, even if people had been inclined, was really impossible. Nevertheless, I think that perceptions of this constitution amongst the population of the new state are of interest. And this is because so much of the scholarship on this constitution is based on perceptions, on the years that, put down on paper in the years that followed and enjoyed the benefit of hindsight. So what did people actually think of the constitution in 1922 itself, without the benefit of hindsight? Well, here we're mostly going to look at media reactions, pamphlets, and scholarly works written in that year, 1922. Yes, these sources have obvious limitations, but in the main, they're all that we have. So, to start, a substantial majority of the media outlets in the 26 counties were strongly supportive of the 1921 treaty and of the emergence of the Irish Free State. And what this ensured is that the constitution of the new state received quite a warm welcome. And there wouldn't have been too much sympathy, at least in the media of 1922, for De Valera's assertion that it was not a free constitution of the Irish people. In 1922, the constitution had become very much associated with the memories of the recently deceased Michael Collins and Arthur Griffith. And their words and their memories were very much repeated when talking about the constitution in December of 1922. The pro-treaty media, however, was also very keen to emphasize the Irish origins, which it insisted pervaded the new constitution. Here we see the Freeman's Journal saying that the Free State begins its life under a constitution of Irish manufacture. We see the Cork Examiner saying that it's a constitution drawn up by Irish men for Ireland. And we see the Irish Times claiming that it is a magnificent charter of liberty. Okay, that's the pro-treaty media. Now let's look at the anti-treaty media. A few key words tell us all we need to know here. Okay. They did not respond in a favorable manner, as you might predict, to the new constitution. And it's fair to say that the response of the anti-treaty media, such as it was, focused virtually entirely on the treaty provisions of the constitution. So, for example, things like the king, the oath, and so forth. And you get comments like this: did our young men die for such a constitution? Now, pro-treaty newspapers, for their part, mocked this near exclusive focus on matters relating to the treaty. They commented, here's the Irish Independent saying, look at all the novel features of the constitution. Its provisions for referenda, for the popular initiation of legislation, for its unusual composition of the executive. All of these things have excited as little curiosity as if they referred to the government of Siam and not to the Irish government. Northern Unionist reaction. Unionist newspapers in Northern Ireland, for example, the Belfast Newsletter and the Belfast Telegraph, referred to the 1921 treaty and the 1922 constitution as sham pieces of paper. As far as they were concerned, the new Irish Free State was not going to be a dominion. It was already, even before it came into existence, practically a republic. And as for the provisions of the new Irish Constitution, well, Northern Unionist newspapers tended to republish and echo the sentiments of the British Sunday newspaper, The Observer, which had this to say: we have never doubted the capacity of Irishmen to draft good laws, What we have been driven to doubt, with the best will in the world, is whether Irishmen can keep them. There was also quite a bit of concern in the Belfast newspapers for the fate of the Southern Protestants in the 26 counties. There was a lot of skepticism as to the value of the safeguards offered them, in particular, the institutions of the Senate and proportional representation voting. As for the Senate itself, it was very predictably an institution welcomed by the Irish Times. But other newspapers south of the border were either silent on this institution for the most part, or in many cases openly hostile to it. Gauging Northern nationalist reaction is complicated by the reality that so many provincial newspapers of the time actually spanned the border. And this is an obvious example, the Derry People and Donegal News. What is abundantly clear is that interest and analysis in the new constitution was as great north of the border as it was south of the border. And the expression that the constitution is being framed for all Ireland, you hear this repeatedly in Northern nationalist newspapers. Now, of course, this was technically true. But as has already been described in the previous paper, under the 1921 treaty, once the constitution came into force, the Northern Parliament would have a period of a month to decide whether they were going to opt for the United Kingdom under the Government of Ireland Act of 1920, which has already been described, or whether they were going to opt for the Irish Free State under the 1922 Constitution. And look, there was no real doubt as to which it was going to opt for in 1922. But under the terms of the treaty, opting for the United Kingdom would have consequences for Northern Ireland. Those consequences being the convocation of a boundary commission. And what's evident in the nationalist media of the time is an expectation that the boundary commission will be convoked immediately after the constitution comes into force in 1922. We know that this doesn't happen. We know that the boundary commission did not work out as expected. This was not known by the nationalist newspapers in 1922. The reaction of the Catholic Church and its media outlets were overwhelmingly supportive of the enactment of the new constitution. And you could argue that this was based on the constitution's association with the achievement of statehood and in hopes for a return to peace and stability after years of conflict. And Catholic media outlets found much to praise in its provisions. For example, the provision of free elementary education. Their one criticism, and it's something that increased in intensity as 1922 wore on, was the absence of any reference to God in the text of the Constitution. And the protests become increasingly intense as time goes on. Here we have a number of letters to the Irish Catholics saying, you know, it is the duty of the government to prevent a godless constitution for a Christian land. And that surely Ireland, Catholic Ireland, will not, in her first act of freedom, officially turn her back on God. The protests become increasingly loud until in October of 1922, the provisional government finally moves to add a preamble to the Constituent Act that brings the Constitution into force, which duly makes reference to God. It acknowledges that all lawful authority comes from God to the people. Okay, looking at key provisions of the Constitution, the human rights provisions get some attention, although not nearly as much as I suspect most 21st century lawyers might expect. The Freeman's Journal, for example, looks at rights like, you know, inviolability of the dwelling, freedom of assembly, freedom of conscience, freedom of religion. But one supposed rights provision that gets quite a lot of attention is the provision that largely abolished the granting of titles of honor to Irish citizens. So in other words, making a person sir this or that, or lord whatever. It's somewhat anomalous, perhaps, as a human rights provision, and it gets quite a lot of attention for whatever reason in 1922. The provision of equal suffrage to women and equal rights to sit in the Oireachtas get quite a bit of attention in 1922, but their practical significance there is greatly exaggerated. You can see from the quotes here, quite a few newspapers, both within Ireland and without, are claiming that this amounts to a total abolition of sex distinctions in law from this point forward. Now, I wonder how many 21st century observers would agree that such an abolition had actually occurred in 1922. The issue of the Irish language doesn't get nearly as much attention, again, as one might expect. Whether that reflects the views of newspaper editors or is reflective of wider views, I leave for yourselves to decide. One of the rare examples of attention actually, though, comes from the Belfast newsletter, which condemned what it called the absurdity of claiming primacy for the Irish language as the national language, given the relatively small number of speakers, native or otherwise. You can contrast that, though, with the reaction of the Meath Chronicle, which actually took exception to the provision that also recognized English as an official language. They believe this shouldn't be done. And in the end, the Meath Chronicle concludes rather grumpily that they suppose that the English language would have to remain in vogue for some years to come, but they didn't want it mentioned in the Constitution. Some of the democratic experiments in the Constitution, for example, the holding of provision of referenda and the popular initiation of legislation, they get a good response. They allow newspapers to emphasize the democratic credentials of the new Constitution. You do get the British daily, the Daily Chronicle, which sniffs that these constitutional innovations have only been chosen purely because they differ from the British usage. One unusual provision was one that declared that the date of every general election was to be a national holiday, and some opponents of the treaty joked that this was the only good provision in the entire Constitution. Unfortunately, it was removed later on. Oh, one experiment that actually did receive quite a lively media debate was the extensive provisions for unelected or extern ministers in the government. And the idea here was to bring in people with special skills into government, but there were always strong doubts as to the wisdom of this idea. And some newspapers came out strongly against the scheme. Here we have the Freeman's Journal saying, fancy experiments ought not to be made in the infant Irish state. And this newspaper and others welcomed the eventual watering down of these provisions, which never proved very successful anyways. Actually, one last innovation, which might surprise some people, that was not universally welcomed, was the innovation of judicial review. Some media outlets expressed concern as to how this institution had operated in the United States of America. Others opposed it on principle. I'll give you this quote from some members of the Labour Party declaring that they would oppose the institution of judicial review to the death. They didn't follow through on that threat, but nevertheless, that was what was said. In conclusion, I mean, most Irish people in 1922, irrespective of their views on the treaty, for them, the Constitution signified the end of an epoch and the beginning of a new one. I mean, for many people and for many media outlets, the Irish Constitution of 1922 was important, not merely for its provisions, but for what it represented. It represented, as the Cork Examiner said, a struggle for liberty for which the country has waited for, the culmination of a struggle for liberty, which the country has waited for a long time. A new start for most of the island of Ireland, at least. A hope for much desired stability, a beginning of the end of a long, long and dark and bitter period of conflict. The Cork Examiner was even confident enough to boast that the new constitution undoubtedly is in advance of the British Constitution. And it concluded, a free Ireland should, under the Irish Constitution, reach the highest planes in industry, commerce, agriculture, science and art, and become a model nation in which peace, industry and progress will help create a golden age. Now we know, they didn't, that this constitution would in fact only last for 15 years. Although one could argue that its core provisions have been recycled in the constitution that we still have to this day. And as for the golden age mentioned by the Cork Examiner, well, let's all hope in these dark days that that's still to come. Thank you very much for your kind attention.
Thank you so much, Thomas. And that brings us to the end of our three superb papers. And now we do have time. We have probably until about 7 o'clock to throw it open to people. Now, first of all, Martin Roach has put a question through. Martin, I don't know if you want to ask the question yourself, if you'd like to unmute and put on your camera and put the question to our panelists. No, well, maybe I'll put it through that he put through. I wonder whether the treaty would pass polling here now. That's an interesting one. Tom, I don't know if you want to.
Maybe Bláthna, this is your paper.
Yeah, I didn't hear the question properly there. I didn't hear the last bit of what you said there, Patrick. If you could just repeat it, please.
I wonder whether the treaty would pass polling only us here now.
Oh, I'd say the treaty would pass polling. I mean, I think that, you know, I mean, it's a completely different situation. It's a world apart, but I think that a big driver, obviously, in what got the treaty passed was that people were completely sick of the violence. And I think that was one of the reasons why, no matter what happened, for example, in Westminster, they just voted in favor of this document. They had had enough. They didn't even need to engage with the terms hugely. It was better than what had been there before. And I think that sentiment comes out exactly in the same way in the Dáil debates, where just the sense of trauma. I think a modern society faced with similar levels of trauma would turn very timid indeed. We'd seem to have a very low threshold for taking any kind of international conflict of any kind. Wars are nowadays have to be conducted by fantastic F-35s in foreign jurisdictions. If there was any kind of sense of violence that was the backdrop to any kind of reasonable settlement, then yes, I think it would. But I mean, it's not hypothetical. It's fantastical, really. But that's my view of it anyway.
Very good. Well, do we have anyone who would like to make a comment or pose a question to one or more of our panelists?
Hello, good evening. I'm not a member. Elizabeth is my name. I'm not going to put on my camera because my bandwidth is so low where I am. I'm in danger of losing all of you. So pardon that. My question is for the three speakers. Thank you so much. It was such an extraordinary, interesting hour, really. Between 1922 and 1937, the differing changes made to the Constitution. I wonder, could I have a comment from any of the three panelists, really, about one, the legitimacy of those changes in the context of violence, which is a big question, I understand. And two, how perhaps that grey area and the Ruane case, which came before 1937, has impacted the idea of legitimacy of legislation in Ireland now, and judicial review. 3 huge questions. I'd be happy to hear even one sentence on any of them. Thank you.
No, thank you so much, Elizabeth. Well, whoever would like to take that.
I'm trying to recall all of them. I suppose first in regard to the legitimacy of the various changes. I mean, you had obviously the extension of the period for making changes to the Constitution without having to have a referendum. But I think that one thing that is striking during that period is how Irish society did look to non-violent methods of bringing about change. The Free State government in its dealings with the British, particularly when De Valera came in, they were prompted by trying to extend the boundaries at every point possible. And there were several amendments and changes. There was a constitution committee set up, in fact, in the mid-20s to recommend changes. Some of those were sort of small changes. But the idea of settling disputes by referendum, I think, took root then. And I think it has continued on very powerfully. Sorry, I'm in the middle of a hailstorm here. I don't know whether people are similarly disturbed, but that's the background noise. I think that was an important feature that did take root. The broad extension of allowing any changes really that could come through at all, I think was probably done in frustration at the difficulties of trying to deal with the interminable problems of Dominion status and the consequential violence that was still ongoing. It was nothing on the same level, but particularly after the assassination of Kevin O'Higgins, I think that sent an enormous shudder down through the Free State government, and indeed the British looked very carefully at that. So I think in some ways the notion that these things were to be counteracted by changes of a constitution and by legislation in the first instance, you can query the validity of that, but whether they could have validly extended the power to change by legislation only. But I think that became the first impulse, instead of the generation of violence up to 1922. So I think that was an enormous change. And while it wasn't trouble-free, I think it did a lot to settle down the sort of the general view of how disputes should be resolved. So perhaps I don't know if I'm answering any of them or all of them, but that would be my just initial reaction to that.
No, that's lovely. Thank you so much. Yes, especially I think it's particularly interesting, the context of legislation against the backdrop of violence. You know, and I think your beautiful comment about how all of us obviously have an aversion to violence, any reasonable person would, but violence now becomes so remote, but yet violence can be other than injury, that is physical, and I suppose we will respond quickly to address it. Thank you so much. It was really interesting. Thank you. Thank you.
Thank you. Now we have a few questions coming through on the chat function, but does anyone want to jump in and ask any questions? Especially maybe some of the other papers as well. Well, maybe we might put Alex's question then. Alex asked, what lessons can we take from the treaty negotiations back then for negotiations of unification today? So that's very much a topical and indeed a controversial and contentious question. So I don't know, John, would you have any thoughts, just even on the idea of whether these are things that should be even talked about?
Well, you know, this is the prompt for the dreadful old Bismarck quotation about lawmaking and sausages. But Lloyd George really was, I mean, a dreadful villain. Probably the one thing on which Michael Collins, Prime Minister Craig, agreed on was that he couldn't be trusted. I mean, adjectively, a superbly accomplished tactician, but really, I can't help thinking back to the government of Ian Macpherson, King's Counsel, briefly Irish Chief Secretary, to be replaced by Hammer Greenwood. And one of the factors, it appears from the recent biography of him in his appointment, is that his wife was one of Lloyd George's mistresses. I think that there really is little to be learned in any respect from the conduct by Lord George of any negotiation.
I don't know.
To give a view there, Patrick, if
Yep, definitely.
I would say, reading the whole process, I would say, first of all, make sure that whatever sides are involved in any of this, that they're all properly briefed.
Speak. I'm on mute.
Sorry, that they have adequate time for preparation. I think the Irish side going into the negotiations were hopelessly caught on the blind. They were dealing with incredibly formidable legal experts on the other side, and they did their best. But in truth, they had none of the support structures that the British government had, and that undoubtedly played against them. If you can keep your own side united, that's a big help. The other thing that I would say is things happen, and things that were not acceptable probably at the start of the negotiations or even the year for ratification became acceptable by the end of it, because things had intervened, things had happened. Perhaps that year is particularly stark, but I think that the attitude of the Conservative government by the end of 1922 was much more assertive in terms of saying, well, you know, we've done with this, we've had enough. We're now going to deal with Cosgrave's government. This is within the treaty. It's a Dominion constitution. So we've had enough of this process, and they voted it through. I think if some of the events had taken place much earlier in the year, before the death of Collins and the death of Griffith, I think circumstances would have been changed, and British reaction by then would have been somewhat different. I think they had seen that the Cosgrave's government was willing to go to enormous lengths to protect the treaty, and that in a sense softened their attitude to it, and they became much more confident in saying, right, be done with it now, get on, get rid of it, and you know, get over it. I think you have to be careful in any negotiation. I mean, there's no doubt Lloyd George was utterly pragmatic, and he thought outside the box, and at one level you could say that he was incredibly effective in what he did, and I'm not sure that the negotiations would ever have reached a settlement were it not for a lot of the skullduggery that he engaged in. So you need to eye up your opponents well and think laterally as to what they might do, playing the public mood, what was released, what wasn't released, picking out particular weak members of a negotiating team, selling one line to one person and another line to another, and then bringing them back together again. It's a very treacherous business negotiating like that.
Very good. Sorry, and Charles Lycett. Sorry, Charles Lycett, you wanted to get in. I know you've sent through the question, but I don't know if whether you want to ask it in person.
Well, can you hear me?
Yes.
Yes, well, it's just a wonderful dissertation Bláthna gave us on this issue. But what interests me is Lloyd George must have been acting on specialist legal advice in all these subtleties. Have we any written trail on that, or on the similar advice being given on the other side? And who was giving it on the Irish side? Was it Hugh Kennedy, or who was it? Or Gavin Duffy? Can she help me on that?
I don't know whether you can hear me now. Can you hear me?
Yes, I can, yes.
Yes. On the English side, the two main characters who were giving the legal advice were Birkenhead and Hewitt. And they, in fact, Birkenhead was recorded as having had, extreme reaction to the suggestion by Lloyd George that he would offer a treaty. I think that they were very well equipped to do what they were doing. They were highly qualified. I mean, Birkenhead was an expert in international law, for example. There was nobody of that stature on the other side, because they were, they just were coming from a completely different position. On the Irish side, you had, during the negotiations, you had Gavin Duffy, you had Childers was very influential. But one of the things that's very striking about the Irish papers is how, and this is what I said earlier, the main group of the negotiators were desperately unprepared for the legal issues that they were heading into. And I think that caught them, they were always playing catch up and going in to face Birkenhead at a meeting. John Charter was another person who was involved. But John Charter had really very little expertise in constitutional law. In fact, although he was there for that. Then after...
Very good. We might close with a final question. Sorry.
Okay.
Sorry, I thought time has beaten us up, but I thought we might end with a final question from a former student of mine, William Quill, who congratulates the speakers on three very interesting papers, and has a question for John Larkin. And the question is, was there any legacy of the All Ireland provisions of the Government of Ireland Act in either Sunningdale or the Belfast Agreement?
Goodness, there's a big question. Well, the 1973 settlement, which found legislative expression in the Northern Ireland Constitution of that year, fell down because of the Irish dimension, which never really got off the ground. As we know now, there are in place a range of implementation bodies pursuant to the Belfast Agreement. But I have to say, one of the, and consideration time beat me during the main paper, I would have liked to have spent some time on the Council of Ireland, because the Council of Ireland didn't formally with the Articles of Agreement for a Treaty and the Free State Constitution, but it petered out and was finally disposed of in the 1925 Act. And in a way, one could say it's a paradox that the chances of unification, albeit initially within the United Kingdom, were probably greater. Certainly the machinery for union was subtle and more developed under the 1920 Act than it was in settlement, because as Thomas said, you had a month for a decision, and everyone knew going in more or less what that decision by the Northern Ireland Parliament was going to be. And there'll be a variety of perspectives on this, but it seems to me that it was a pity that institutional links and opportunities were not present as both Northern Ireland and the Irish Free State moved into the 1920s.
Very good. Now, some lovely messages coming through. Julita saying, excellent presentations. Many thanks to the three speakers for researching and illustrating less well-known aspects of the constitutional changes. And thanks to the Society for opening the event to non-members. And that was echoed by Patrick Hillfeather, who says, as a non-member, I would like to thank the Society and the speakers for three very stimulating presentations. Well, I've been delighted that so many have been able to join us, and I think that's probably one of the few advantages of Zoom. Pia Sullivan, by the way, had an interesting one, that the historian Linda Colley said in a podcast recently that the Irish Free State had published the new constitution in a booklet with other constitutions as a way of announcing to the world that we are here as a state, taking our place among the nations of the earth. And can anyone verify that that's correct?
They can. Sorry, I can finally speak. There was a car alarm going off, so I couldn't join the earlier conversations without deafening everybody. But yes, such a volume was published by Darrell Figgis. It was part of the research that they did in drafting the Constitution was to look at other constitutions of the world. So they actually published twice, in fact, in 1922, and a second edition expanded in 1924, a book containing constitutions of the world, which included the new Irish Free State Constitution. And it was actually a very useful document that was used in drafting different constitutions around the world, because you've got to remember, this is a time before the internet, before you could easily access foreign constitutions in the English language, by the way, because they've had to all be translated. And it was used in drafting, for example, the 1937 Constitution. So yes, such a book did exist, and it's available to download for free, actually.
Very good, and some more lovely messages coming through from people who really enjoy. So I'm going to call on our Senior Vice President, John Gordon, to deliver the traditional vote of thanks. As we conclude our spring discourse and pay tribute to the incredible work that has gone into this from our three speakers tonight.
Thank you, President. I'm very pleased and delighted to offer a vote of thanks on behalf of the Society to our three speakers this evening. This is the second time we've had the discourse online and in a somewhat similar format. And I have to say, I think it has been quite successful and may well, despite hopefully the removal of COVID restrictions, be something that we will continue to do in the future, given the huge numbers that we've had, because generally our discourses are probably between 40 and 50 people in attendance, usually due to travel. But this has been a very successful format, and I've no doubt has raised the profile of the Society significantly. We're very fortunate this evening to have within our membership the most learned of scholars from both the legal profession and academia, and that's what makes up our members and what makes the Society so unique in this island. Certainly the contributions by John Larkin, Bláthna Ruane and Thomas Mohr are just fantastic this evening, and I'm sure everybody thought that the speakers were particularly eloquent and erudite on topics which gave us a fascinating insight to what is a period of turmoil in both Irish and British history from that point of view. The tradition of the Society in recent years has been to publish our discourses in due course, and I've no doubt that despite only having 15 minutes of fame this evening, that those discourses will be published in some format and make an excellent contributions to our publications in due course. Normally, we would express our thanks and appreciation by means of applause. So on this occasion, I would urge you simply to go to the clap hands reaction on your screen and make the recommendation and appreciation of our speakers in that method. Finally, I would hope that many of the non-members who have had the opportunity to hear the discourse this evening could be persuaded to join the Society. The subscription entitles you to free publications, attending at the discourses, and is certainly worth what really is a very modest subscription. We have a number of excellent books in the pipeline, and I'm sure you will not be disappointed in the publications that are coming down the line in the future. But finally, it's been wonderful to see so many people from, in fact, so many jurisdictions. I noted Germany, United States, Italy, United Kingdom, and Australia. So thank you all very much for attending, and we hope that we will either see you or meet with you in Belfast in November for the annual general meeting, and the discourse there will be given by the President. Thank you.
Classic mistake. Thank you so much, Vice President, for that. And just to bring this spring discourse to a conclusion, I think it's been a very successful event. Wonderful that so many people from across the islands and around Europe and around the world have been able to join us tonight. We will be meeting for our AGM and Windsor discourse that I'll be delivering. It might be in person in Belfast, it might be online, it might be a hybrid of the two, but we will keep you informed, and it will be open to members and non-members. So thank you so much for joining us, and good night.